My name is R.S. Gates. The Texas Government Code from Section 552 is under the fundamental philosophy of an American constitutional form of representative government that adheres to the principle that government is the servant and not the master of the people. It is the policy of this state that each person is entitled, unless otherwise expressly provided by law, at all times to complete information about the affairs of government and the official acts of public officials and employees. The people, in delegating the authority, do not give their public servants the right to decide what is good for the people to know and what is not good for them to know. The people insist on remaining informed so that they may retain control over the instruments they've created. The state legislature came up with that. I didn't bring that up on my own. Last week, Commissioner Jones said the primary election is irrelevant. The statement was supported by documentation submitted by the elections administrator. In dictatorships, elections are irrelevant. Commissioner Jones also said the election was mute. Since the policy of the court is to ignore voters, taxpayers, and citizens, I'm left to conclude that you have confused an election with a silent auction where it goes to the highest bidder. Commissioner Snell apparently got it because he said, shouldn't we do this before the election so they will know what they're running for? That's a pretty simple concept. Counsel to the court, taxpayer funded, twice said, you're always going to have this problem. I understood he was talking about interfering with the election. This is absolutely not true. Had the court made the decision prior to November 9th, there would have been no problem because that is the first day to file for a place on the ballot. You could have done it when Judge Laster Boone resigned in October 2013. I know someone will be squealing that there's not enough time, but the issue has been on the table since 2010. If the objective was to streamline services, I think you could have got it done in 3 years. Back to counsel for the court. This is the most important question. What was that incompetence because you didn't know what the law was, or was that propaganda to further the scheme of the court? I think that's a valid question. I realize I'm in the wrong place to get any answers relevant to the people remaining informed and about what their government's doing, but I think the question is valid. The saying is that those who ignore history are doomed to repeat it. Former criminal district attorney John Segrist wrote in reference to the Ashmore decision, Tarrant County versus Ashmore. Ashmore was decided in 1982. It held that the Commissioner's Court had received a grant of power from the people of the state and from the legislature to perform the action here complained of. That is, to abolish offices and declare vacancies by redistricting after notice of a hearing. Those forced out by this action had no recourse. It follows that Article 5, Section 18C, created post-redistricting officials, was approved by the voters in 1983 to overturn that aspect of the Ashmore decision. It was approved not out of fondness or fairness to the individual in the now abolished office, but to foster the interests of the people and the state. Thus, the public is defended from anyone who from time to time, for the convenience of the people, redraws lines eliminating a justice of the peace here or a constable there, which would in effect disenfranchise the voters of an abolished or redrawn precinct who did not have the opportunity to vote for their inherited officials. From time to time, for the convenience of the people, redistricting may appear to override the will of the voters or change the outcome of elections. Today, office holder, holdover, appointee, post-redistricting official all have one thing in common. Then the individual cannot, by his or her actions or decisions, extinguish the right of the state and its people to have the benefits provided by an official. This was made even more clear considering Article 5, Section 18. The Texas voters could have just as easily rejected the 1983 amendment to that article and left Ashmore the law of this state. But they didn't, and it isn't.
Thank you. Okay, anyone else come forward? Okay,